Rule 5.120. Administrator ad litem and guardian ad litem. Appointment. When it is necessary that the estate of a decedent or a ward be represented in any probate or guardianship proceeding, and there is no personal representative of the estate or guardian of the ward, or the personal representative or guardian is or may be interested in adversely to the estate of the ward, or is enforcing the personal representative or guardian's own debt or claim against the estate or ward, or the necessity arises otherwise, the court may appoint an administrator ad litem or a guardian ad litem, as the case may be, without bond or notice for that particular proceeding. At any point in a proceeding, a court may appoint a guardian ad litem to represent the interests of an incapacitated person, an unborn or unascertained person, a minor, or any other person otherwise under a legal disability, a person with a developmental disability, or a person whose identity or address is unknown if the court determines that the representation of the interest otherwise would be inadequate. If not precluded by conflict of interest, a guardian ad litem may be appointed to represent several persons of interest. The administrator ad litem or guardian ad litem shall file an oath to discharge all duties faithfully, and upon the filing shall be qualified to act. No process need be served upon the administrator ad litem or guardian ad litem, but such person shall appear and defend as directed by the court. Petition. The petition for an appointment of a guardian ad litem shall state to the best of petitioner's information and belief the initials and residence address of each minor, person with a developmental disability, or incapacitated person, and a year of birth of each minor who has an interest in the proceedings. The name and address of any guardian appointed for each minor, person with a developmental disability or incapacitated person, the name and resident address of any living natural guardians or living natural guardians having legal custody of each minor, person with developmental disability or incapacitated person, a description of the interest in the proceedings of each minor, person with a developmental disability or incapacitated person, and the facts showing the necessity for the appointment of a guardian ad litem. Notice. Within 10 days after appointment, the petitioner shall serve conformed copies of the petition for appointment of a guardian ad litem in order for any guardian, or if there is no guardian, to the living natural guardians or the living natural guardian having legal custody of a minor, person with a developmental disability, or incapacitated person. Report. The guardian ad litem shall serve conformed copies of any written report or finding of the guardian ad litem's investigation and answer filed in the proceedings, petition for compensation and discharge, and the notice of hearing on the petition for any guardian, or in the event that there is no guardian, to the living natural guardians or to the living natural guardian having legal custody of a minor, person with a developmental disability, or incapacitated person. Service of petition and order. Within 10 days after appointment, the petitioner of an administrator ad litem shall serve conformed copies of the petition for an appointment and order to the attorney of record for each beneficiary, and to each known beneficiary not represented by an attorney of record. Enforcement of judgments. When an administrator ad litem or guardian ad litem recovers any judgment or other relief, it shall be enforced as other judgments. Execution shall issue in favor of the administrator ad litem or guardian ad litem for the use of the estate or ward, and the money collected shall be paid to the personal representative or guardian, or as otherwise ordered by the court. Claim of personal representative. The fact that the personal representative is seeking reimbursement for claims against the decedent paid by the personal representative does not require appointment of an administrator ad litem.
If you're interested in any of our services, please call 321-206-3603 or visit easlerlaw.com to book a consultation.